Ms. Dudley. Morning.
I have Tashawn Morris for a bond hearing. If I may approach, I have a letter. I did go copy to the state.
Okay. Okay. All right.
Your Honor, we are here in 22 CF 1436. It's a violation of probation. We're set for a motion to set bond. I believe the motion was filed by the Public Defender's Office, and I believe they set the hearing also for the other case, but I didn't see a motion filed in that case. Mr. Morris is alleged to have violated probation by committing new crimes and by some technical violations. And keep in mind, probation is not up, so a lot of technical violations are not something that would have to be done at the time he was violated. Mr. Morris was working with the cleaning company when he was arrested. He has 4 children, 3 children live with him. He needs to be able to help take care of those children. He has no prior failure to appears. He states he's always turned himself in when he does have a warrant. The grandfather of his children had passed away in October. The mother has written a statement I provided to the court this morning. The allegations in this case, they're alleging that Mr. Morris was in a vehicle and that there were narcotics found in that vehicle. If you read the actual report, he never saw Mr. Morris driving that vehicle. One part of the narrative says that he did, and then the next part where he gives a longer explanation states that he had suspicion that Mr. Morris was driving that vehicle, but he never saw Mr. Morris driving that vehicle. We would ask that a bond be set, a reasonable bond be set in this case, in this violation of probation, so that he can get out, get back to work, and be able to help take care of his children.
What's the allegations of the violation?
The allegations are that there were narcotics in the car, fentanyl, marijuana. I don't know if there's anything else that they allege. Cocaine, I believe.
His new law violation, Your Honor. So his new law violation is trafficking in fentanyl. It's been tested by FDLE. The results are 5.85 grams, which is a 7-year min-man trafficking in fentanyl, and also 3 counts of possession of a controlled substance. So he was on probation, which is what Ms. Dudley's seeking a bond on the VOP, because the VOP, the bond was revoked when he committed the trafficking in fentanyl. So he's not entitled to a bond as the state's position on the VOP. He picked up a very dangerous charge, a very serious charge, and his criminal history does include multiple felonies and multiple misdemeanors. Like I said, he's looking at a 7-year min-man on the trafficking in fentanyl.
Your Honor, if I may, I would like the court to keep in mind that when you're dealing with possession of a narcotic, they have to prove he had possession of the narcotic. The officer in the PC makes it seem as if Mr. Morris was in the car and he did a traffic stop and Mr. Morris was seen leaving the vehicle. What he says, though, in his narrative is that he believed Mr. Morris had been driving the vehicle. He saw Mr. Morris driving the vehicle like 12 hours earlier. That doesn't mean that Mr. Morris was in that vehicle at the time he stopped it, because nobody was. The body camera shows nobody was in the vehicle. The vehicle wasn't even on when he pulled behind the vehicle.
Well, when is his VOP hearing set for?
It has not been scheduled. I just got on the case. I do have depositions, I believe, scheduled in March on the case.
Well, with a 7-year minimum mandatory, if he's looking at that, I'm going to leave the bond the way they are.
Yes, sir.
Thank you.
Your Honor, that's all I have.
Thank you.
Thank you.
Here's your letter.
Yes, sir.
Mr. Switek.
Good morning, Your Honor.
Morning.
Your Honor, I'm here on behalf of Andrew Armon, A-R-M-O-N. It's 2014 CF 1953. It's a motion for early termination of probation. This is, like I said, a 2014 case. It was originally an aggravated battery domestic. Mr. Armon came back from being deployed in the Middle East and had a drinking problem.
Where's he at?
He's in North Carolina.
Is he supposed to appear by Zoom or anything like that?
No, I'm just here on his behalf.
Well, what's the state say?
Your Honor, this case involves a victim, and I've communicated with her, and she objects to early termination. Another point, I'm sorry, that I want to bring to the court's attention is the fact that indeed he has violated probation already. So it's not quite accurate that he never violated the terms of probation.
I didn't say that. I didn't say that. I didn't get to that.
All right, well, go ahead, keep going. I'm just wondering why he's not here. If it's
All right.
important to him, I would think he'd be here, but
2018, he had a DUI, DWI in North Carolina. He got a new term of probation of 5 years at that point. And as of today, he's surpassed the 2/3 mark, and he's looking for termination.
and he's picked up a new charge somewhere in North Carolina?
In 2018, that's why his probation, he got a new term of probation of 5 years. In
I'm gonna
2000.
let it keep going. I'm gonna let the probation keep going. Thank you.
Thank you, Judge.
Mr. Stewart?
Good morning, Your Honor. May it please the court, Your Honor, Brad Stewart, present on behalf of Mr. Dean Thomas Cook. Judge, this is 22 CF 803. Your Honor, we are currently in the process of finding placement for Mr. Cook in a group home. We originally thought that we had an opportunity to do so in Panama City. However, they would not take Mr. Cook based on the allegations, charges, and criminal history. We are currently working with John Barnes as well as the ADP program and finding a placement for him. Judge, what is our next court date, if I could put us on that for status, as well as if we cannot find him placement, Judge, I need to move forward with a motion for release on this particular
Some
matter.
kind of like miscellaneous day?
Yes, Your Honor.
What about February 27th?
That'll work.
That's fine for the state,
Is that
Your
good?
Honor.
Okay. Why don't we do that?
That's our plan, buddy. Yes, sir.
That's release on that.
That's our plan, yeah.
Okay, on the 27th of February.
Yep.
Hardy? Thank you. Which client was it?
Conrad Franklin.
Franklin?
Judge, we can pass Mr. Harvard. I wanted to approach on that anyway, so it's going to take a little bit.
Okay.
Yes.
Your Honor, we've got an agreement in this case. Mr. Franklin's going to admit the violation of probation as well as the new charge. Sign right there, date right there. Honor, in case 2015-1363, Mr. Franklin's going to admit the violation of probation to sentence as follows: revoke and terminate his probation. 2 years community control with GPS at $1 a day. The GPS must be on before he's released from jail. $100 VOP fee. In his new case, which is 24 CF 151, it's going to be also a concurrent 2 years community control, $515 fines and court costs, and you'll have the GPS in that case as well.
Franklin, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
All right, thank you. This is 24 CF 151 and 15 CF 1363. In 24 CF 151, you want to enter a no contest plea to the charge of failure to register a vehicle on a sex offender
Yes, sir.
requirement. And then in 15-13-63, admit that you violated probation. Is that correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You wear the rights you're waiving by entering this admission and plea?
Yes, sir, I do.
Has anyone forced you or threatened you to enter this admission and plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Hardy's done for you on your case?
Absolutely, sir.
Court finds the admission and plea is freely and voluntarily entered. Court accepts it. In 24 CF 151, sentence to 2 years community control, $515 fines and or court costs. Adjudicated guilty. You're sentenced to, is that it, the 2 years community control?
Yes, Your Honor.
Okay. And in 15 CF 1363, the court's going to revoke and terminate probation. And it's a new term of probation?
Yes,
Of 2 years community control, GPS, $1 a day, $100 VOP fee, adjudicated guilty. Can't be released from jail till a GPS monitor is affixed.
Thank you, Your Honor.
Is
That's
that
what we
it?
meant.
That's it, Your Honor.
Okay, thank you.
Thank you.
Yes. Ms. Merrifield, are you here today? Okay, what case we got here? Is that, that's going to be, we need this one a little bit later, don't we?
Judge Bernie Merrifield on behalf of Jared Skyles and 18 CF 3045. We have reached an agreement, if I may approach.
Yes. Is this going to be a impact statement on this?
Not at this time, Your Honor. It's my understanding this is only going to be an entry of a plea to the court. We'll set sentencing off so Ms.
Yeah.
Sandler can be here.
Okay, thank you.
may approach, Judge?
Yes.
Thank you, Your Honor. And
All right.
18, would the court like me to read it into the record?
Yes, please.
Thank you, Judge. In 18 CF 3045, Mr. Skyles withdraws his previously entered not guilty. He is entering a no contest plea. As to count 1, it is going to be the lesser included offense of second-degree murder, first-degree felony. Count 2 is grand theft auto is charged, and count 3 is resisting officer without violence is charged. As to all counts, he enters an open plea to the court with no agreement between the state and the defense. He understands that his minimum sentence under the Florida Criminal Punishment Code guidelines is 253.5 months. Department of Corrections with a maximum of life in the Department of Corrections. We are requesting a sentencing hearing at the end of February so that Ms. Sandler can be available. And there is, the PSI requirement has been waived, Judge.
All right, this is 2018 CF 3045, State of Florida versus Jared Adam Skyles. Mr. Skyles, would you please raise your right hand to be sworn? I swear the testimony you give before this court is true, so help you God.
Yes.
Okay. You want to enter a no contest plea to lesser charge of second-degree murder or first-degree felony. Count 1, grand theft auto. Count 2, and resisting an officer without violence. Count 3. Is that correct? All right. Are you aware of the rights you're waiving by entering this plea? Did you read and sign this plea and sentencing agreement form? Has anyone forced you to or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Is there any DNA evidence that is exculpatory that would benefit the defendant that has not been provided to him or his attorney by the state?
Not that the state's aware of, Your Honor.
All right. Is there a stipulation on the factual basis?
Stipulation of the factual basis, Judge.
Are you happy with the work Mr. Flaherty, Ms. Merrifield have done for you on your case?
Yes.
Court finds the plea is freely and voluntarily entered. Court accepts it and will set the sentencing to, sentencing is at the discretion of the court. The court will waive PSI. And it's at, did you want me to waive PSI?
Yes, Judge, and if we could request an afternoon hearing at the end of February.
How about February 29th?
That's fine, Your Honor.
Is that okay?
Or Ms. Sandler.
Thank you, that would be fine with the defense.
Okay.
And that would be the 2:30 docket, Judge?
Yes.
Thank you.
Is there anything else on this plea that needs to be brought out?
Not at this time, Your Honor. We'll provide a score sheet at the time of sentencing and
Okay.
present any victim statements at that time.
All right. Okay, thank you.
Thank you, Judge, that's all I have this morning.
Thank you. Who else we got? Mr. Patel, Mr. Stewart, do you want to come back up?
I apologize, Judge.
Pardon?
Asking who else?
Sorry.
Harvard?
And please, Court, Your Honor, Brad Stewart, on behalf of John Russell Harvard, Judge, 22 CF 1810. Can the state and I approach, please?
All right. Dang it.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Judge, that's all I have on this morning's docket.
right.
May I be excused till this afternoon?
15-minute break. Thank you.
All rise, please.
What happened to Centerfit?
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at davestilepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Mr. Patel.
Good morning, Judge.
Morning.
Jay Patel on behalf of Jonathan Wayne Brown. 22 CF 2134. This is a change of plea.
All right.
At this time, Mr. Brown changes his previous plea of not guilty and tenders a plea of no contest to the amended information. The understanding is that he will plead to count 2, misdemeanor battery is charged, count 3, lesser included trespassing, count 4 as charged. In exchange for a plea, the state dismisses count 1. The understanding is there will be 24 months of probation. Court costs as required by state and county ordinance. No trespassing at the victim's residence. No contact with the victims, and reserve restitution for 45 days. Count 2 and lesser included count 3 are both misdemeanors, so there'll be 12 months of probation concurrent. May I approach?
All right. All right, Mr. Brown, would you please raise your right hand to be sworn? You swear the testimony you give for us court's the truth, so help you God. Thank you. This is State of Florida versus Jonathan Wayne Brown, 22 CF 2134. You want to enter a no contest plea to count 2, battery, a misdemeanor, count 3, trespassing, a misdemeanor, count 4, child abuse without great bodily harm, 3rd-degree felony. So you want to enter a no contest plea to those charges, correct?
Sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Yes, sir.
Are you happy with the work Mr. Patel has done for you on your case?
Absolutely.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count 2, you are, let's see. Oh, and the state's agreed to dismiss count 1. Is that correct?
Yes, Your Honor. That's the
All right.
agreement.
On count, let's see, count 3, you're sentenced to 24 months probation. Standard court costs and fines as required by state and county ordinances. And
Judge, that'd be count 4. That's the felony. And
4, I'm sorry, count 4.
then 2 and 3 are the misdemeanors, which would be
Yes.
concurrent probation.
Okay, well, you got 24 months probation, so I was going to give him 12 months concurrent on each one of the
Yes.
misdemeanors. So on count 4, 24 months probation, standard court costs and fines required by state, county ordinances. No trespassing at victim's residence, restitution reserved for 45 days, no contact with victim. And on the 2 misdemeanors, 12 months standard probation, concurrent with each other and concurrent with count 4. Adjudication withheld on all counts. Anything further?
Just 1 second, Judge. May I approach with the score sheet?
Yeah. All right. This is a downward departure through a negotiated plea agreement. All right, anything further?
No, Judge.
And I guess, all right, and count,
Just for the record, on the clerk sheet or the minute sheet, I saw 2 victims. So I assume it's both victims that he's not have contact with?
That's correct. They're a husband and wife.
yeah.
Thank you.
And then state's going to follow an all process on count 1.
Yes, Your Honor. The state dismisses count 1 in exchange for a plea to the other counts.
Okay, thank you.
Thank you, Judge.
This Ms. Rivers.
Yes, Your Honor. Okay. Okay, if you would, if if you don't mind.
We got any out of custody out there?
I do not, Your Honor, not for this morning, no. I do believe that Mr. Gibbs has some out of custody. I know of at least two, Your Honor, that we
Let
could
him
address
come up.
right now.
Are you doing Mr. Gibbs today?
Yes, Your Honor.
Okay.
The first one would be Amber Foreman, 23 CF 1866.
Okay.
And Your Honor, I'm going to request to continue this case. I have spoken with the state. We're working on an agreement. So if we could put this on a pretrial date, give me an opportunity to bring her in and meet with her and go over the agreement with her.
February 26th? Is that okay?
That works for the
All right.
state, Your Honor.
Thank you. February 26th.
At 9 a.m.
Yeah.
I'll put it on here for you.
Okay, thanks.
All right, Your Honor, the next person that I spoke with was Rebecca Glover, 21 CF 939.
Okay, she out of custody?
She is, Your Honor.
Where is she?
She's right there, Your Honor, in the gray jacket. She's coming up, Your Honor. Your Honor, Mr. Gibbs was trying to work out an agreement in this case, and he needs an opportunity to go over the terms with Miss Glover. If we could get a continuance on this.
About February 27th.
No objection.
Okay?
February 27th at
All
9
right.
a.m.
Okay, thank you.
Thank you. Your Honor, this is Randall Odum before the court on 23 CF 1947 and 23 CF 730. We've reached an agreement in this matter, if I may approach.
All right. Mr. Odom, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God.
Sir.
Thank you. All right, you want to enter a no contest plea in 23 CF 730, to possession of a firearm by a convicted felon. Let's see.
And Your Honor, that would be for the 1-year community control followed by 2 years of probation. Forfeit the firearm.
All right. And then in 23 CF 1947, you want to enter a plea to,
The lesser felony battery.
yes, that is count 1, felony battery, and then count 2,
Be null pros.
okay, count 2 is going to be null prost. So that's what you want to enter a plea to, is that correct?
Sir.
Okay. Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
Sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Sir.
Are you happy with the work Mr. Gibbs and Ms. Rivers have done for you on your case?
Extremely.
Court finds the plea is freely and voluntarily entered. Court accepts it. On 23 CF 730, you're judged guilty. You're sentenced to 12 months community control, followed by 2 years of regular probation, concurrent with 23 CF 1947, forfeit the firearm. No possession of any weapons or firearms. 415 court costs, $100 cost of prosecution, $100 PD fee, waive cost of supervision. In 23 CF 1947, the state's going to dismiss count 2, false imprisonment, correct?
Correct, Your Honor.
Count 1, you are, that was to a lesser included offense, felony battery. You're judged guilty, 12 months community control, followed by 2 years probation, psychosexual evaluation, sign up for evaluation within 30 days. Beginning recommended treatment within 90 days of evaluation, 767 court costs, $100 cost of prosecution, $100 PD fee, waive cost of supervision, no contact with Rhea Ham, no alcohol or drugs without prescription. You're judged guilty, and that is concurrent probation with 23 CF 1947.
Your Honor, there's one other issue.
Yeah. Yes. Y'all want it off the...
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Yeah, he can get him a card for medical.
We will monitor that as it's supposed to be.
All right, yeah. He can have the medical marijuana, get a card. Okay, thank you. Okay. Tell Mr. Gibbs in the future, don't string out all this stuff in a big, it's hard for me to figure out what he's talking about. You know, put it in a paragraph with each count. He's got it all strung out, and he's got it typed so little I can hardly see it, and then he's written through, and he's used pen, and it's hard for me to, you know, he may need to, you know, he needs to, this is not right. I mean, this is too hard for me to figure out with all this stuff strung out all over the page.
Yes, sir.
I'll chew him out when he gets here. Sorry you had to have it.
I did it, Your Honor.
Oh, you did it?
I
Well,
did.
don't do it that way.
She waited this
Do each count as a sentence, so I can, not strung out all the way down the page, and I, you know, and, well,
Anything is better than mine.
all right.
She said, okay, I'll tell you. Heart attack is better than mine.
Your Honor, this is Michael Owen. He's before the court for, we've switched over to my cases, Your Honor.
Okay.
He's before the court on 19 CF 2090. He's here for violation of probation. Your Honor, the court previously gave him a bond, and he has been waiting ever since then for Escambia to pick him up. What is this?
That's the waiver of extradition that I got, where I was still incarcerated here during the time of the hearing in Escambia. And I know the judge said that he can't do anything about it, but it's been 14 days, Your Honor.
Yeah, he's been here 14 days. They still haven't picked him up from Escambia. For the misdemeanor. He does want to offer up to the state. He's willing to plea to credit time served, the jail informed him that he has over 14 months of credit on his case. The court previously imposed a 12.1 month suspended sentence.
The score is 29.025 months DOC, so the state can't legally agree to that.
Cannot.
I'm not agreeing to a downward departure.
So what's he wants to enter a plea to a violation of probation?
For time served, Your Honor, yes, because he
This
says
isn't
he's
set
done.
for a plea today.
Right,
This is a
that's true.
status
I mean,
hearing, so
If the
if
court
this
so
is a
want to
plea to the
handle
bench,
it.
then we can set it for a different date.
We'll set it for February 27th or something. I mean,
Your Honor, the only thing is with that, is I don't know what's going to happen in Escambia, and I don't want to be in the same situation I'm in right now, to where if Escambia does come get me in the next couple days and I don't make it back before the 27th, I mean, I'll do my best part to allow Ms. Rivers to know that I'm over there still. I just don't want to be in the same situation where I get an FTA here because I'm over there.
well, I can't help that.
I
mean,
know
all
you can't,
I can't control what they do. All I can do is take a plea and have a sentencing at some. Ms. Glisson's not ready for sentencing today, are you? Or
First I've heard that.
yeah, I mean,
So, and all we can do is waive your appearance for the 27th.
yeah, waive appearance, and there won't be a failure to appear from me.
That's what I'm asking,
If
Your Honor.
Miss Rivers will do that.
That's what I was asking for.
Even if we issue a failure to appearance, if you're in jail, they would dismiss it, so. Okay.
I just didn't want it to affect the bond that I previously have at this time. That's all I was trying to get across.
No, that's, from what I've heard, that's not a problem with me. So, we'll see you February 27th, I guess.
Yes, sir.
Okay?
Thank you.
All right. All right, 15-minute break. Thank you.
All rise.
Donna?
9 months. 9 months.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Background Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Mr. Lundy, this is Judge Gonteric. What case are you here on? Mr. Lundy,
Yes, sir. Yes, Your Honor.
what case are you here on?
I was here on the Peterson matter. It was originally set for today, but then it got moved to the 5th, and I've just taken over this file. We did not appear at that hearing, but I've just cleared it up with, and plaintiff's counsel did not appear, but another co-defendant did, and you instructed them to prepare an order about depositions and things of that nature. And I just stayed on for just in the off chance there was still a hearing going forward.
Is that a civil matter? Civil case?
Yes, it is, Your Honor.
Okay, well,
Yes, it is, Your Honor.
that was all my case managements yesterday or the 5th or something, so.
Yeah,
All right.
yes, Your Honor. I got you. Yeah.
Okay, thank you. Thank you,
Judge.
All right, bye.
I've done this in a long time.
You're fine.
Your Honor, if I can step in on Ms. Tremmel that we just sentenced. She was reinstated to drug offender probation.
Okay.
I just want the court to know so we don't turn around and do another violation report. She is scheduled to terminate probation in August of this year. Since she got put on drug offender probation, a requirement is to enter and complete a substance abuse evaluation. We're going to refer her to that. Is it okay with the court if she is in compliance with these conditions while her termination date approaches, that she be allowed to terminate? If not, we're gonna turn around and submit a VOP.
Fine with the state. Do we need to put a condition like evaluation within 30 days? That help?
Okay, if we do that, but if she's complying with treatment. when
As
her
long as
time-
she's complying with treatment, even though it's not finished, then it can, okay.
And we go ahead and on that front, we request that the outstanding monies be converted to a civil lien at termination.
No objection.
Yeah,
Thank you.
Thank you.
That way it
okay,
won't come back.
very good.
Thank you, Mr.
Now, who we got?
Your Honor, this is Lindsay Wood. This is 23 CF 2861. We've reached an agreement in this matter, if I may approach.
Yeah. All right, you are Lindsay Wood.
Yes,
Would you
sir.
please raise your right hand and be sworn? You swear the testimony you give for is course the truth, so help you God. You swear to tell the truth?
Oh, yes.
Okay.
She's very nervous, Your Honor.
All right, nothing to be nervous about. I'm just gonna sentence you to jail. So you want to enter a no contest plea to count, let's see, introduction of contraband, a third-degree felony, count 1, and possession of paraphernalia, a first-degree misdemeanor, count 2, right? You want to do that?
She says she also has trouble hearing.
You want to do that?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yeah.
You wear the rights you're waiving by entering this plea? You wear your rights? You're waiving them?
Yes.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, very.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 1 and 2, 120 days, Okaloosa County Jail, both counts concurrent. How much time has she got?
She said she's been here since December 24th.
You got 2 or 3 weeks to go or something like that. You get credit for time served. And $5.15 court costs, $100 cost of prosecution, $150 PD fee adjudicated on both counts. Okay?
Yes, sir.
All right, thank you.
Thank you.
Okay.
Okay, thank you so much.
Your Honor, this is Rusty Dwayne Rogers before the court on 19 CF 2691, 22 CF 60, and 23 CF 1681. Your Honor, I was just speaking with the state a few minutes ago about a possible alternative sentencing. I need opportunity to meet with my client, go over it with him. So if we could put this on for 27th?
All right. We'll bring you back on the 27th, Mr. Rogers, okay?
I'll be out there to talk to you, okay?
Thank you.
Mm-hmm. You okay? Your Honor, this is Brandon Rowell. Is it Rowell?
Yes, ma'am.
He's before the court on 23 CF 2640 and 24 CF 1250. The 24 CF 1250 is an add-on, Your Honor. We've reached an agreement in this matter, if I may approach.
All right. Brandon Scott Rowell, right?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for is court's truth, so help you God.
Yes, sir.
All right. This is State of Florida versus Brandon Scott Rall, 23 CF 2640, 24 CF 1250. You want to enter a no contest plea to count 2 DUI and in 24 CF 1250 count 1 grand theft, correct?
And Your Honor, in the 24 CF case, the state is going to file a no prosecution.
On count 1, right?
That's correct, Your Honor. That's right. 24 CF 212 will be dismissed and a no prosecution will be filed in exchange to the plea in 23 CF 2640.
Says, I have 24 CF 1250, no pros, right?
It's 24 CF 212 will be no pros.
I wrote the case, she's saying I wrote the case number.
I'm reading here 24 CF 1250, right? Is that the case?
No, Your Honor.
That's not the case? Well, look, come look at this. Maybe see, you wrote it like Chinese. You know, I don't read very good trying to figure out, it's got to be in a sentence. And this looks like 1250 to me. I don't like Chinese plea forms. I like American plea forms. So.
May I approach, Your Honor?
All right.
So you're saying you'd like me to write it in here?
Like a sentence, not, down like Chinese writing or something, or Japanese or whatever. All right, so it's not 24 CF 1250, it's 24 CF 212, right?
Yes, sir.
And 23 CF 2640. I think you got 24 CF 1250 over here. I'm going to change that to 24 CF 212. I believe that's the grand theft one, right?
Yes, sir.
All right, so 24 CF 212, that's out. That's being null-prossed, right?
That's correct, Your Honor.
And then count 1 of 23 CF 2640 is going to be null-prossed, correct?
Correct.
Possession of a weapon by a convicted felon, so that's out, right?
Correct.
So he's pleading to count 2. All right, that's DUI, Duball. That's what you want to enter a plea to, sir?
Yes, sir.
Okay. Sorry about this confusion. I'm trying to make sure we give you the right sentence. We don't want to give you something that, you're not supposed to get. So we try to make sure this is correct. All right, did you read and sign this form? I mean, we changed some of the numbers on this, but not the terms.
Yes, sir. I read it.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, I am.
She's a much better lawyer in trial and representing people than she is in writing plea forms. But Court finds the plea is freely and voluntarily entered. Court accepts it. All right. This is on count 2 of 24 CF 212. Judge guilty, 12 months probation, no alcohol or drugs without a prescription, forfeit firearm, no possession of weapon, 6 months driver's license revocation, $2,000 fine, $50 cost of prosecution, standard court costs, $100 PD fee, 1 year interlock, DUI school level 2, 10-day vehicle impoundment, 1 victim impact panel, waive cost of supervision, and you may do community service for fines and to pay fines and costs. So it sounded like a rather standard sort of a DUI type.
Just to be clear, Judge, he cannot, there's a $2,000 statutory fine for the DUI. He cannot do community service.
On that.
To work that off. I don't believe it's because it's statutory.
Yeah, if he can, he can, but if he can't, that's the statute, but, so.
And just to be clear, so that sentence for the DUI is 23 CF 2640 as to count 2. State will announce a null process to count 1 in that case, and state will also announce a null process in 24 CF 212 to the only charge, which is grand theft auto.
Right. All right. Well, sound like Ms. Rivers did a pretty good job for you, getting especially that, getting that one, well, 2 of these counts dismissed. So, okay. You happy with her work?
Yes, sir.
Okay. All right. Is there a, let's see, this is, oh, misdemeanors. We don't need a plea. Okay. Thank you. Thank you.
Sears.
Okay. It's going to take forever at this rate, but we'll do the best we can.
Your Honor, we've reached an agreement in this matter. If I may approach, this
Yep.
would be Milan Sears, 20 CF 489.
Mr. Sears, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God? All right. This is State of Florida versus Milan Sears, 20 CF 489. You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You wear the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case? Court finds the admission freely and voluntarily entered. Court accepts it. Sentences you to 90 days Okaloosa County Jail. Credit for time, sir. No. Credit for time starting at January 14th, 2024. Reinstate and extend supervision by 1 year. Convert supervision to community control. All original terms and conditions. Waive cost of supervision. $100 cost of prosecution. $150 PD fee. And witnesses can appear via Zoom with a notary for any violation of community control hearings. Adjudicated guilty. So it looks like you got about 90 days. Well, you got 90 days jail, but you got credit since, it looks like you got almost a month of that done or so, okay? Okay, thank you. Anything further on that? Okay.
Your Honor, we're reinstating with community control from his original term date of 4/28/24, so we're going 1 year from there.
Yes.
Yeah. Mr. Owens, what you got?
Bosco Jordan.
Is it a plea or something?
I wanted to talk to the court and say about it.
All right, well, let me, oh, yeah. Oh, there she is. All right, who is this now?
Your Honor, this is Douglas Centerfit. He's before the court on 23 CF 2440. We filed a motion for a bond hearing.
Yeah. All right.
He is charged with burglary of an unoccupied conveyance. He's being held on this charge without bond because he has a new law misdemeanor charge. He previously posted a bond of $3,500, which was later revoked. He's asking the court to grant him a new bond, preferably an ROR bond. His home is in foreclosure. He's trying to get out. He wants to try to save his home.
What does the state say?
Your Honor, we were negotiating a plea agreement for probation, so it would get out.
Want to bring him back later today, and if he enters a plea, I'll give him probation. You want to do that?
Yes, Your Honor.
Okay. You want to talk to him about it, or?
Yes, sir.
All
And
right,
if
we'll
we could
bring him
just,
back. Maybe we can get you out with a probation or something today instead of a bond.
we could do them for 1:30.
How about that?
Thank you.
Okay.
Thank you, Your Honor. Mr. Owens want to jump in?
All right, Mr.
Your Honor, I think we may have worked out a bond agreement on this one. This is
All right.
simple bond hearing. If I can have just a moment with him.
Yeah.
Your Honor, before the court is Christopher Watson, 23 CF 2450. We filed a motion for a bond reduction. I believe the state and I have reached agreement. It would be $5,000 cash or professional on each count. Before it was 20, I think it was around 20. Your Honor, it would be a ankle monitor that would be attached prior to his release, and
No contact with the victim?
yes, no contact with the victim.
All right. 5,000 cash professional on each count, ankle monitor before release, no contact with the victim,
And Your Honor, that would also include pretrial services, please.
and pretrial services supervision. And don't mess up or you'll be back in, okay?
Sir.
All right, thank you.
God bless you.
Thank you.
Mm-hmm. Right. Right.
What about Witchfield? Wilkes?
Yep. Yep. Your Honor, this is Alonzo Wilkes. He's before the court, Your Honor, for a bond hearing.
Okay.
You will give me just a moment to switch over. Your Honor, he is before the court on a bond reduction hearing. Your Honor, the court previously imposed bonds, he believes around $38,000. He is unable to post such high bonds. He is a lifetime member of the community. He has friends, family. He has a job at McDonald's. He has children. He is asking the court to reduce his bonds, maybe consider pretrial services, to have no contact with the alleged victim, but allow him to get back out, go back to work so he can support his children.
Please.
Well, what does the state say?
Your Honor, Mr. Wilkes is charged with domestic battery by strangulation, assault, threat of death or violence against law enforcement, resisting without violence, possession of cocaine, and drug paraphernalia. He was given a bond at the pretrial detention hearing for, he was being held on the strangulation and the threat against a law enforcement officer. He was given bond just, I guess that was maybe last week or 2 weeks ago. He does score prison. He scores 17.1 months DOC. He does have he has 2 failure to appear convictions, one from 2019 and one from 2018. He has a failure to appear from 2023 that was dismissed in exchange for a plea in county court. So he also has, in his criminal history, a grand theft of a firearm, robbery by sudden snatching, possession of controlled substance. He's got a prior battery offense. He's got disruption of a school function. He's got trespass, another resisting, the failure to appear, 2 of those driving offenses. He's got several other resisting without violence. He's got possession of marijuana, And the victim in this case has indicated she's terrified of him.
All right, that's what I wanted to know, what the victim said. So I'm going to leave the bonds the way they are. Thank you. Thank y'all.
And we can do the juvenile at 1:30, the state and I were talking about.
What was the juvenile's name?
Whittington. Landon Whittington, Your Honor.
Okay, what, the other gentleman's name was, that just left?
Alonzo Wilkes.
Wilkes, okay, I just,
That's correct.
all right, what else? Mr. Owens, what case is it? Come on up.
Let's go, Jordan.
Jordan.
Judge, I'm James Owens, and this is Roscoe Jordan before the court. He's charged with violation of his probation. I believe this court originally sentenced him to 3 years of probation with an 18-month suspended state prison sentence. He's charged, Judge, he lives in Santa Rosa County, he works in Escambia County, and he was pulled over. There was a tag that was expired. It was his girlfriend's car. And he was cited with driving while license suspended. Unknowingly, he was suspended for failure to pay child support. That has been satisfied, and it's been restored. And then, of course, the other stuff they allege where he hadn't finished paying the fine, but he still had, I believe, about half of his probation to do. I was wanting the court to consider, he's been in about 30 days, restoring his probation because it was not a willful violation. The probation he had prior knew that he was traveling from Santa Rosa to Escambia to work. He got a new probation officer that was not aware of that arrangement, so alleged that as well, that he drove out of the county without permission. So he's got that count as well. I was hoping we could resolve it today by restoring him.
No, Your Honor, I'm not ready for that today. It's set for arraignment today, so.
All right, well, you want to, what we'll do is enter denial of your violation of probation and set him for February 27th, see if we can get it resolved.
Thank you, Judge.
What time would that be?
9 o'clock?
Thank you, Judge.
If you can come up with something sooner.
He's telling me.
Judge.
We don't have a sooner date than that.
You need to tell him I paid all my fines are paid. Prosecute.
You want to bring him back this afternoon and y'all talk?
I only have 2 months left on probation, and my fines are paid.
Can we approach the bench, Judge?
You want to bring him back this afternoon? I didn't say yes. I didn't say y'all could approach.
Oh, I'm sorry, Judge.
Yes, we can. We can, Judge. We can.
wanna-
He's telling me all his fines are paid off.
I understand all that, but she's not, apparently not ready for a trial here today or a hearing. You know, the state's got to have an opportunity to respond, but if she feels like she wants to look into it, or, I mean, I'm willing to look this afternoon, or.
I had offered, Your Honor, instead of imposing the suspended sentence, revoke and terminate current term, new term of 2 years, drug offender probation. That's my offer.
No jail, prison time?
Correct, Judge. He will be given another chance.
Judge, he will accept that.
Well, write it up on some plea form for me. Okay?
Wait, you'll get a chance in a minute.
All right.
You'll get a chance to address the court.
You want to write it up and get a plea form and write it up for me?
I will. Thank you.
We'll bring you back, okay? Who's next? Miss Flowers, okay?
11. So, yes, Your Honor, I have Shane Thomas Collier. Just confirming
All right.
it's been signed. We have reached an agreement with the state, if I may approach.
All right. Mr. Collier, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God. Okay. You want to enter all right, this is 22C, State of Florida versus Shane Thomas Collier, 22 CF 663, violation of probation, 22 CF 665, violation of probation, 22 CF 2690, violation of probation, and 23 CF 1917, fleeing or attempting to elude, driving license suspended or revoked, and resisting without violence. So you want to admit that you violated probation, and then enter a no contest plea to those other charges in 23 CF 1917, correct? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by this admission and this no contest entry?
Yes, sir.
Has anyone forced you or threatened you to enter this admission or no contest plea? Are you under the influence of any drugs or medication that prevents you from knowing what you're doing here today? Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea and admission is freely and voluntarily entered. Court accepts it in 22 CF 663, 22 CF 665, and 22 CF 2690. Court's going to judge guilty, revoke, and terminate probation, a new term of 2 years community control, followed by 3 years of standard probation concurrent with 23 CF 1917, $100 VOP fee times 3, $150 cost of defense times 3, and waive cost of supervision. In 23 CF 1917, count 1, judge guilty, 2 years community control, followed by 3 years standard probation concurrent, and that is with the 22 CF 663, 22 CF 665, and 22 CF 690, 2690. So that's concurrent. In 515, court costs, $150 cost of defense, waive cost of supervision. In count 2, you're judged guilty, sentenced to time served. Count 3, judged guilty, time served. Anything further?
No, Judge, that's the agreement.
You got
Thank
it,
you, Your
Ms.
Honor.
Flowers?
Yes, Your Honor.
Okay.
Yes.
Okay, thank you.
So, Your Honor, this is Bridget Dobbs. I don't have a case number in front of me. I was just recently appointed to her BOP. We would enter a denial.
All right, you're charged with, I'm sorry.
Go ahead.
You're charged, Ms. Dobbs, with violation of probation. Your attorney, Ms. Flowers, entered denial and will set her for, when's a good day for this? For a VOP hearing? 27th?
That's fine, Your Honor.
27th of February. Okay?
Thank you.
Next one.
Your
All
Honor,
right.
this is Trevor William Fubble.
Yes.
We're here on 21 CF 609. Mr. Fubble, I was appointed to represent him in the matter of his post-conviction relief motion that was granted an evidentiary hearing. Basically, he's asking for the state to amend his sentence to include, how many days? 59 days of incarceration in Alabama. The state had made the offer of splitting the time and awarding 30 days credit roughly. He believes he's entitled to the full 59 days, so I believe according to what's been ordered, I guess we'll have to set this for an evidentiary hearing unless.
Well, what is the state?
I had offered, Your Honor, to split it in half, 30 days. I was going to agree to 30 days instead of 59.
Was he held on some other case in Alabama?
Yes, it was an Alabama case that he had, and he was serving time over there for that. So it's the state's position that he shouldn't be entitled to any
Yeah,
of the
I did
credit.
some research on this, and the case of Zagaldo versus State, it's up to the discretion of the court, and I need to find out whether you were being held solely on Florida charges. I'd probably give you the 59.
What it was, sir. They dropped all charges of their wanting Florida to come get me.
Oh, is that right?
I'm not aware of that, Your Honor. I would have to research. I don't know.
I can,
What's he here on? Well, he's been brought back from prison, right?
correct.
And how much time did he get in prison? For prison? How much time you
5
served?
years.
5 years?
I leave it up to the court.
I'm gonna give him 59 days credit for time served. Okay?
Yes,
Thank you,
sir.
Your Honor.
Thank you.
All right. Where are you doing your time at?
Madison CI.
Okay. Well, I gave you 59 days credit, extra credit. So, Miss Anna, that'll be reflected, sent down to the Department of Corrections, amended judgment. Yeah, prepare me an order so we make sure he gets it.
Yes, Your Honor. I'll have that submitted by end of day.
Okay. All right. Well, good luck to you.
Thank you,
Thank you.
sir.
All right.
Thank you, Judge.
Just trying to save you some work.
Thank you, John.
Your Honor, this is Jeremy Nathan Jernigan. We're here in 23 CF 28. We've reached an agreement with the state that I've previously gone over with Mr. Jernigan. He's just executing the agreement.
All right, Jeremy Jernigan, would you please raise your right hand and be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes, sir.
Okay, thank you. All right, you want to enter a no contest plea to a lesser in 23 CF 28, you want to enter a no contest plea to a lesser included charge of felony battery, a third-degree felony. And on count 2, a lesser included offense of felony battery, a third-degree felony. And so that's what you want to do. 2 lesser included offenses, correct? Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea is freely voluntarily entered. Court accepts it. Count 1. Judge guilty. I'm having a hard time today. Just reading all these Chinese written plea forms. Not Ms. Flowers, because hers is written American with like a paragraph, so you can read it very nicely. Judge guilty, 11 on that count 1. Judge guilty, 11 months, 29 days, Okaloosa County Jail with credit for time served. Complete the ECLC program in jail, followed by 2 years of standard reporting probation. Enroll and complete ECLC outpatient program. $515 court costs, $150 cost of defense, no contact with victim. Reserve on restitution, waive costs of supervision. On count 2, you're sentenced to a judge guilty, 11.29 months jail concurrent with credit for time served. Complete the ECLC program in jail, followed by 2 years standard probation concurrent. And I think that's it, right?
Yes, Your Honor.
Okay, thank you. Thank you, sir.
Your Your Honor, this is Amber Michelle Lunn in 22 CF 2322. She's been previously, was adjudicated incompetent to proceed and sent to Florida State Hospital where she has been deemed competent to proceed. If the judge has, have you had a chance to review the order? Okay, Your Honor, and so we would just ask that the state would stipulate to the findings.
State would stipulate to the report being reviewed by Your Honor.
All right,
At the
yeah.
discretion of the court. State has no other evidence to present.
Okay.
Okay. Thank you, sir.
We would ask the court to find her competent to proceed.
All right, court finds her competent to receive. When that doctor, what doctor wrote that report?
Dr. McDonald, I believe, did.
I thought it was McDonald. I read so many of these things, I can't keep up with who I just read, but did y'all see where we have a new expert witness list on these experts? That I think McDonald's still doing them, but
The most recent, I believe the most recent evaluation was conducted at the Florida State Hospital. So it was from one of their.
theirs, I thought I just read one from Dr. McDonald, but
Most recent one I have
Okay,
is from
I'm up next, so.
Jennifer Edwards.
Edwards.
Yes,
Okay.
that was her
All right,
assigned
yeah.
counselor. Mhm.
Okay, well, so we got to put her on the docket.
Yes, Your Honor, if we could set her for, I plan to file a motion to address her bond and set that for the 27th, so if
All
we want to
right,
go ahead and put it
February
on.
27th.
Thank you. And Your Honor, I have one left on the docket, Betty Westbrook. Set today to complete her payments. If the payments were completed, the state was, the state was going to announce a dismissal, but if not, the
Ms.
court was gonna
Westbrook, okay, is the
sentence her.
state going to dismiss or what?
I've not received any notification that anything has been completed.
Oh,
Had the money this morning, and let me, what happened? Okay, she's saying that the clerk's office needs the judge to sign a paper so that she can pay the amount downstairs.
on a paper? What, a promissory note or something?
Maybe because sometimes when the cases aren't closed,
Wait, Miss, do you have record that she paid something, Miss Anna?
so you weren't able to pay?
No, they told me.
Oh, like a restitution, stipulation that she could pay restitution to the clerk, maybe that's what we need to prepare. I think I've done that before. When a case is pending, they don't know where to put the money.
Court to order it.
Mhm.
That's fine. Restitution.
Okay.
Also, all the court
And I believe that was what you were going to pay, correct? She has the money to pay the restitution.
You want to just continue this to February 27th and see, give her time to finish up whatever it
We can,
is?
and if we need to put it in writing with the clerk, so we could say, restitution can be paid to the clerk, that's
Yeah.
fine. And it's to this address? Yes. Right. And then also
Wonderful.
I show that we're waiting on her to show proof of the community service hours being completed.
Sound like there's a lot of stuff she hadn't
Well,
done, so.
we've allowed her to a little more time because she did get rejected from the PTI program because of.
All right, we'll make it February 29th. Try to
And
get,
if she doesn't, I just want you to be aware, if you don't show the proof of completion being made, then. Okay.
Yeah,
She's
we'll
already entered a plea.
We'll do sentencing on the 27th if,
29th.
oh, 29th, my bad, yeah. Thank you.
All right, what else we got?
That's all I have today, I believe.
You
Your Honor.
finished?
If I may be excused. Oh, okay,
I was
that's
going
right,
to
that's
say,
a
I
new one.
thought I missed one, but Kevin Russell.
Yes,
Okay.
Your Honor. Kevin Russell, Jennifer Flowers for Kevin Russell. I was just recently appointed, so I would, is he on for VOPs today? Yes?
He is.
I would enter a denial for purposes of today and ask to be set for the next miscellaneous date.
All right, Mr. Russell, you're here on a VOP arraignment, and Ms. Flowers has pledged you denial that you violated, and we'll set you for February, 29th? February
Yes,
29th,
yes, Your Honor.
okay?
Thank you, Your Honor.
Judge, can I recall Roscoe
Jordan?
Jordan?
Okay. Roscoe Lamarcus Jordan.
Judge, we have an agreement on Roscoe Jordan. I've reduced it to in writing.
All right.
I wrote some of the terms, the state attorney wrote some others, so
Okay.
he needs to sign the document. Probation. They're revoking the probation and terminating probation, placing you back on 2 years drug offender probation with a curfew of 7 p.m. to 7 a.m. No driving without a license. They said you gotta get your license restored. Reinstate the previous requirements that have not been.
7 p.m. to 7 a.m. How long does that last?
I'll talk to her about that. But you initially have to undergo that for a few months. I'll talk to her about expanding that. Is that what you want to do?
Yeah, to work. I got kids.
Okay, well, you got to sign this agreement.
And are they aware that I paid all my fines off?
Yes, I'll explain it to the judge. You'll be allowed to address the court.
Right here?
Yes, sir.
Can I go today?
All right, Mr. Jordan, this is 2018 CF 1318. Would you please raise your right hand and be sworn? You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
Okay. So this is also 2020 CF 1365. And he is entering a admission to violation of probation, correct, on both these cases?
Yes, sir.
And Mr. Jordan, did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission? You aware of the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Owens has done for you on your case? Court finds admission freely and voluntarily entered. Court accepts it. Court's going to revoke and terminate probation, put you on 2 years drug offender probation with a curfew 7 p.m. to 7 a.m., which can be, I'm going to put, which can be modified for work purposes. You check with your probation officer if you got a job change or something, you can, yes.
Does this curfew last the whole 2 years, Judge?
Well, how about that? Is it lasting 2 years?
Yes, Joe.
Any way to work with that?
Yeah. You can always petition to modify it if you want to.
The state and I talked about that. I think she wanted him to do a period of a curfew, and then we talked about potentially, didn't we? Did we not? No, we did not.
Potential, no, we didn't talk. What do you mean? I would agree to this, Your Honor, to do it for 1 year, and if no violations, then it can remove the,
All right, we'll do that. 1 year, no violations, and it can come off, the curfew. In the first year, you can ask your probation officer, it'll modify, so your job, for example, doesn't get you off work till 8 p.m. or something like that, okay? So, but right now, the curfew is 7 p.m. to 7 a.m. for first year. If no violations, it can come off, and it also can be modified during the first year for work purposes.
Thank you.
And then no driving without license, and reimpose previous requirements, adjudicated guilty.
thank you, Judge. That's
Waive
everyone.
cost of supervision.
Thank you, Judge. He did want me to let the court know that he has paid all the fines and costs, and he did pay the rearage for child support to get that squared away. Understand?
Yeah, concurrent probation, right?
Yes, yeah,
All right,
concurrent probation.
concurrent on both cases.
He wanted me to let the court know he only had 2 months left on his probation. I explained to him this was our agreement with the state attorney for him to be released today.
Well,
these were the terms.
That's it. Okay. All right, thank you.
Thank you, Judge.
Okay.
Hello.
All right, this is William Andrew Minshew, case number 21 CF 1025 and 21 CF 2182. Is this arraignment on Mr. Minshew, VOP arraignment? All right, Mr. Minshew, you're here on a violation of probation on this, on these cases that you were apparently put on probation. There's been an allegation you violated. How about an attorney to represent you on this? I'll appoint the public defender to represent you.
Need one.
Okay.
I can't afford one while I'm locked up.
All right, I'll appoint public defender, and Mr. Williams is here. He'd probably be your attorney, and he's going to plead you denied that you violated.
Now, Judge, and I'll go out to the jail and see him. We'll talk about his case once I get the paperwork.
Okay, if you get it resolved, bring him back up. But we'll set him for February, February
27th, I think, is the date.
27th, or what about the 26th?
26th is a docket day, Judge.
Oh,
Or pretrial conference.
29th.
29th.
Let's make it the 29th.
All right, I'll come out to the jail and see you once I get your violation report and all that in, okay?
Yes, sir.
Okay,
All
thank
right.
you. All right, who is this going to be?
Landon Whittington, Your Honor. He's set for arraignment this afternoon, and he is set for bond reduction hearing this morning.
All right.
Your Honor, this is Landon Whittington. He's before the court on 23 CF 2875, 23 CF 2876, and 23 CF 2879. He has been handed the informations. We're going to enter not guilty and request trial by jury on those 3 cases. And then if we could address his
All right.
bond.
Let's see. So he is charged in 23 CF 2875 with, it looks like, 4 counts. And then 23 CF 2876, it looks like 9 counts. Is that the only 2 case numbers?
3, Your Honor. There's one more case
See,
number.
I don't have a.
There's 23 CF 2879 where there's 6 counts.
So I don't have that on my docket.
Okay.
It's probably, okay, I got another docket. So on that, so he's being arraigned on all that?
Yes, Your Honor.
Okay.
We'll enter not guilty plea, request trial by jury.
Okay.
Your
Yeah.
Honor, for the bond reductions, for 23 CF 2875, the counts 1 through 3, the bond was set at $25,000 per count. On count 4, it was set at $1,000, and that's cash professional. On 23 CF 2876, it's $25,000 per count. And on 23 CF 2879, it's $25,000 per count. And that's what it was originally set at, Your Honor. His bonds, our understanding is his bonds were totaling over $451,000 but prior to coming to court, he was arraigned again, and his bonds are now at the jail showing in the amount of $900 and something thousand. The state and I have looked online. The only thing additional that is on the clerk's website is an additional juvenile case, a juvenile case number, and the courts don't set bonds on juvenile cases. They do pretrial detention. So the best I can figure is bondsman set twice. At any rate, Your Honor, the bonds are too high. He is unable to post these bonds. He is 14 years old. Best that I can tell, he's never been in trouble before. He has no way of making, close to $1 million in bonds. The court, that the court has previously set. We're asking that the court set bond in the amount of, it looks like there's 19 counts. One count is at 1,000, so the 18 counts, if the court would set it at no more than, $1,000 cash professional with ankle monitor and pretrial services, something maybe that the family could possibly afford to post.
These bonds were set at first appearance?
Well, they were set originally by Judge Oberleeson when the case was transferred from juvenile court to adult court, and then the case, the best we can determine, because there's no paperwork, bonds were set again just recently for an additional $500,000. So at any rate, he can't afford to post these bonds.
And, Your Honor, I'm asking the court not to take any action on this juvenile case. This is not, the state was not noticed for that.
Correct.
So all we have before us is 3 felony cases. So if we could address those bonds, I'm not sure. I just became aware of this new juvenile case. I don't know if they're direct filing it or what. But apparently there's another case coming that's similar in nature to this one. He's currently charged within the 3 cases that are before us today with 13 total felonies between the 3 cases. He's got 6 misdemeanors, and they include the misuse of 911. The felonies include extortion, false report of bomb threats, and quite frankly, Your Honor, the evidence that has been retrieved from this case, from his phone download, is very, very disturbing. But just to brief the court on the facts of these cases, one count in a case is for him the defendant calling a high school in Texas, stating the police department stating there was pipe bombs on the campus of a high school that had almost 3,000 students. He demanded $10,000 or he would detonate the bomb. As you can imagine, every agency in that area responded. The school was on lockdown for over an hour and a half. Every parent was notified. There were helicopters dispatched. There were canines dispatched, and that's just one of the counts. The electronic devices in these cases revealed that this defendant would record himself while he was calling police departments all throughout the country. And he was crying, or fake crying, saying that he had just murdered his parents. And he would give details such as where the wounds were located and how to apply pressure properly. He also would give the name, when he was asked, what's your name? He would give the name of the person who actually lived at the house. Now, how he found that out, we're not sure yet. We're still going through the discovery. But the units would respond, multiple, and all these counts that you're seeing, multiple innocent families had SWAT teams across in different states arrive at their house at gunpoint, only to learn that there's innocent people in here who have no idea what's going on, when really it was the defendant calling in these fake murders of his parents, but giving the names of the people who lived there to make it seem real. He recorded himself doing this. He used voice alternating machines to do this. It was very sophisticated. He downloaded an app on his phone which gave out mixed telephone numbers. So all he had to do for every call was to go through this app. He had to create a phone number, or the phone number was given to him, and so the phone number was not able to be traced back. So he would tell the officers that if the officers came to the residence to respond to this homicide, he would kill the officers and he would kill his brother or himself. On several occasions, he claimed there was pipe bombs. This was done over a period of 4 months, and what we have right now, apparently there's more charges coming because there was multiple calls that were made that we believe are linked to him. However, for right now, we have charges for Florida. He made to Indiana, Texas, Ohio, and New Jersey. Now, When,
He may be facing charges in those states too.
no, sir, we're charging him here because the calls were made here in our jurisdiction. Now, I don't know what he's facing in other states, but we did bring charges here. On the defendant's cell phone and laptops, Your Honor, there are video montages saved to his phone of homicides showing gruesome decapitations, videos showing school shooters entering schools with firearms, victims laying on the ground. There's also photos that are taken of firearms.
Well,
that-
I think I'm gonna leave the bonds with, it sounds like this is a classic danger to the communities. If he's calling in these, and all these officers are having to respond, and schools being closed, and I'm gonna leave the bonds the way they are. Thank you. All right, who are they?
First one, Jalen Rogers.
Mr. Rogers, come on up. Hello, Mr. Rogers.
How you doing, Judge?
Good. Let me find you on the docket. Is he number 11, you said? Page 11?
Page 6.
Page 6. Jalen James Ray Rogers, right?
Yes, sir.
Okay. You are here on a violation of probation allegation, and it appears you don't have an attorney. How about letting me point you a free attorney, public defender's office? Hang on, they may have an offer for you.
Your Honor, I believe the defendant has completed the community service hours, is that right?
Yes, ma'am.
Okay. And at this point, Your Honor, we would just ask the VOP to be dismissed and send all money to collections or civil lien.
All right, you have any objection to me dismissing it and just sending it to any monies owed to collections?
No, sir.
Okay.
And revoke and terminate.
Revoke and terminate. I'm gonna revoke and terminate your probation. Send any monies you owe to collections, and you can just pay it when you can.
Yes, sir.
Okay, so, and I further order you not to break the law.
Yes, sir.
Okay, thank you.
Thank you.
Cynthia Smith. She is here. Ms. Smith, this is 21 CF 1381, violation of probation allegations. Is there an offer for Ms. Smith? She's got some.
It looks like she also brought in proof of community service hours, and you've completed your treatment since your violation. And the only thing she hasn't completed, Your Honor, is the monies and the vehicle impound.
The vehicle impound was supposed to have been taken care, I got that repoed, my car repoed.
That's something I believe can be handled administratively with the DMV.
All right.
Failure to do the impound, so at this point, I would have no objection to dismiss the VOP and revoke and terminate all monies to.
You want to do that? Okay, I'll revoke and terminate probation, all monies due to collections, pay it as soon as you can. And so the Department of Motor Vehicles will deal with that impound issue. You have to talk, probably maybe ask for a hearing in front of them, okay?
Okay, thank you.
Okay, thank you. And don't, order you don't break the law. Okay, Mr. Williams.
I'm ready. Did we handle Roscoe Jordan? We did?
Yeah, we did.
All right. Did we get appointed on it?
Mr. Owens represented.
Mr. Owens has it?
Yeah,
Okay.
James Owens, yeah.
Judge, Mr. Hart's before the court on a motion for bond reduction.
Would you tell me his name again?
Hart, H-A-R-T.
Okay. Christian Ethan.
That's correct, Judge.
All right.
21 CF 2283.
Right.
Mr. Hart's been incarcerated since January 9th. He's got a no bond. He's requesting a bond of $3,000. He's currently employed by Crestview Electric Company. Has been there about 4 years. Resides here in Crestview. I put the actual address on the bond motion. Has lived in this area for 7 years. Has 4 children and a wife that live in the area. His youngest child is only 4 weeks old, so he has substantial ties to the community. If we can put him under oath, I'll have him testify that what I just told the court is correct and
Well,
let
let me
him.
ask the state, his bond is no bond right now?
Yes, sir, it's a VOP.
What is the state saying?
I say it's a VOP. It's,
You got an offer for him or
Yeah,
something?
I
Actually, it's
did.
not.
She's got an offer for you.
We're trying to get him into the rehab
Williams.
program, but we don't have an answer yet, Judge.
Well, I would be agreeable to that, but he has to stay in jail until a bed is open or he can enter the program. That would be my request.
Now, looking at it, it looks like you made an offer of just 2 years straight to community. No, that included the bars to bed. So we're waiting on an answer from the rehab program. We have submitted the application for him.
If he gets out on bond, then we would have to modify that offer. I won't keep that open. I agreed because he said he was gonna do bars to bed.
The offer on it is
So-
bars to bed, Judge, but he had asked me to bring a bond motion for him.
Well, so what's happening if I let him out on that 3,000 cash or professional, then Miss Leon's saying she's not gonna agree to that offer, so that's off the table. He could end up with jail or prison, or I don't know what he's looking at. Is that correct, Miss Leon?
Yeah, he's facing prison potentially.
Well,
He doesn't score a minimum guidelines if that's what the court likes to know.
so you wanna be out on bond?
Judge, I
Might,
think, or, sir, I think what the judge is suggesting is that you might wind up with a worse offer than waiting and seeing if you get admitted into the inpatient rehab. I think where we're looking at right now is Phoenix House. So do you want me to continue to proceed with the bond hearing, or do you want me to pass it out and let's see by the next day whether we have an
Want
answer?
to continue it and see if he gets admitted to whatever?
Judge, he's concerned that his kids aren't going to
Because I got it.
have any place to live, apparently. Are you the sole provider for the family?
Well, what about 3,000 cash or professional and?
It's fine,
You
Your Honor.
could
The
you
problem I have
consider a
with that.
drug patch to make sure that he doesn't use, since that seems to be the concern. Would you be willing to wear a drug patch?
Well, wait, Miss Leon.
I was just saying that if his concern are the kids, so the intention to go to the rehab wasn't really there. You know, because if he goes as an inpatient, he cannot be out working and do all the other stuff.
Right, but
So I got issues with that.
he would be able to make proper arrangements for them to be looked after while he's in rehab. What he just indicated a couple
I'm
of
gonna have
minutes
to
ago.
leave it up to the court. I'm not agreeing.
Well, it sounds to me if I would let you out on bond, Miss Leon's not agreeing to any type of sentence, correct, Miss Leon? You want to just be free to go with whatever you feel like is just.
May I, if it's not, I may make an amended offer. If he gets out on community control, enrolls and attends Emerald Coast Life Center.
You want to bring it
I'll agree
back
to
this
that.
afternoon?
Judge, I can do that. I've got 2 other people I'm going to have to talk to briefly for this afternoon. 2 of them were just brought in from the state prison. So we can put him on the back end of it behind Mr. Herbert. He's set for 2 o'clock. And that'll give me some time to talk with him some
Miss
more and
Leon,
lock up.
You want to, I'm not forcing you to do anything, but, you know.
No, no, I'm fine with
You
that.
want to do that?
Yes, Judge,
Okay,
yeah,
well,
thank
y'all-
you.
Okay.
He's going to take that, Judge. I'll take a few minutes, get it drafted up for him.
All right.
Okay. I don't think I'm going to be able to get it done up this morning. The
Just take it.
internet section is down, so I can't even send to the printer.
We'll take a plea this afternoon.
Thank you, Judge. All right, so they're going to bring you back this afternoon, okay?
Thank you.
I don't have anything to the arraignment docket. May I be excused?
We got, what time is that? Oh, okay, yeah.
Okay. Are you Ms. Hitaffer?
Exactly, yes, sir.
Okay. All right, Judge, this is Christy Hitaffer, 21 CF 2950. We had her transported in to enter a plea, but she had not been brought in from the state prison when I went out to the jail to try to see her. Ma'am, we do have an offer to resolve the case for 21 months running concurrent with the state prison sentence that you've got now. I just need to talk with you about it, so I'm going to ask the judge to bring you back at 2 o'clock this afternoon.
Okay.
Okay?
That's perfect.
All right, good.
So you, I want to sign it over.
All right, thank you, Judge.
All right.
Judge, we have a negotiated plea in this case.
All right, is James Levi Jaggers, correct, sir?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
Okay. You want to admit that you violated probation? You got to say it out loud so we can record it.
Yes, sir.
All right. Did you read and sign this plea form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams done for you on your case?
Absolutely.
Yeah,
Court
they
finds,
agreed to the 240.
court finds admission freely and voluntarily in. Court accepts it. Judge you guilty. Revoke and terminate probation. 240 days county jail with credit for time served on each count. Concurrent. $100 cost of prosecution, $50 PD app fee, $100 PD fee, send outstanding costs and fees to collections. And that's it, right?
That's correct, Judge.
Okay, thank you. Thank you, sir.
No, he's got a straight 240.
All right, what's next? Jones?
That's correct, Judge. Mr. Jones is here for a bond hearing.
Xavier Jones, okay.
Judge, if I can obtain some, well, in the interest of time, Judge, he's been incarcerated since his arrest. He's got a no bond on the VOP, and he's got $15.5 thousand on the new law violation. He has been working at KFC, lives here in the area, 275 School Avenue in Crestview, has lived in the area his entire life. Mr. Jones, what kind of bond can you make? How much you figure you could give a professional bondsman if the court gives you a bond on the VOP? 1,000? You mean $100 for professional bondsman or 1,000 to professional bondsman? The difference is, would be either a $1,000 bond or a $10,000 bond, because the bondsman is going to charge you 10%. Which one? I just need to know which one to ask for. Sorry? Okay. So he's requesting 1,000 on the VOP, Judge.
What does the state say?
Your Honor, the state objects simply because the new law is sell, manufacture, deliver drugs. He was, of course, on probation when he was arrested for that. He scores a minimum guidelines of 18.15 months. His prior record includes violation of pretrial release based on domestic violence, carrying a concealed firearm, battery, possession of controlled substance, driving while license suspended, and couple more misdemeanors. The offer is 20 months DOC for Mr. Jones.
Well, with all that, I'm gonna leave the bonds the way they are.
Yes, sir.
Okay. Maybe y'all can get it worked out and with some kind of deal.
Yes,
So,
Judge.
okay, thank you. Thank you, sir. Langley, right? Troy Langley?
That's correct, Judge.
Okay.
Judge, this is likewise a bond hearing. Mr. Langley's been incarcerated since June 18th. He currently has a no bond. He's requesting a bond of $5,000. He's employed with Baymont Inns and Suites. Has worked there since September of '23. He's got a local address that's listed in the bond motion. He also has a brother and sister who live in Crestview. He has ties to the community. He's lived in Crestview for 10 years and in Florida on and off for twice that time. So he has substantial ties to the community and is requesting a $5,000 bond.
Been in jail since last June or since, you said June?
No, I'm sorry. That was piped in by the software. That would have been his original arrest date. He's been in jail since he was arrested on the VOP.
When was that?
25th of December.
December 25th, Christmas Day, Judge.
Okay, so what does the state say?
Judge, this is a VOP case that he's asking for a bond on. He's not entitled to a bond. Furthermore, when he was put on probation, November 5th of 2021, he absconded pretty much immediately. He didn't do anything. And the next time we saw him was Christmas Day of 2023. He's been absconding since November 5th of 2021. Couldn't locate him after a warrant was issued. So despite over 2 years, he couldn't be found. He didn't do anything. The state would ask that he be held on no bond for absconding, failure to complete treatment, failure to report, failure to do community service hours, victim awareness panel. He didn't do anything. So
It sounds like a flight risk to me, so I'm gonna leave the bond the way it is.
Thank you, Judge.
Next court date, February 29th.
Lewis?
All right, this is Derek Lewis?
Yes, sir.
Okay.
Judge, likewise, this is a bond hearing. He's been incarcerated since his arrest, looks like back on December 17th. He currently has a $325,000 bond. He can't make that. Sir, how much bond do you think you could make?
10,000.
10,000? All right. 10,000 to a bondsman, that would be a $100,000 bond. Or $1,000 to a bondsman. 1,000 to a bondsman? All right, so he's asking for a $10,000 bond, Judge. He is currently employed, Hilton Grandview Vacation. He's a houseman there. Has a local address over on West Edney. He's lived in this area for some 20 years.
Well, what does the state say?
Your Honor, this defendant is charged with a PBL, burglary of dwelling while armed, aggravated battery with a deadly weapon, 2 counts of violation of domestic injunction. An injunction was issued in November of 2023 against the victim, and he committed a burglary of a dwelling against the same victim just a little over a month after the injunction was granted. He broke into the victim's house, cut her with a knife in front of her children, and acknowledged he wasn't supposed to have contact with the victim. The state is terrified that if he gets out, that he will kill her due to the fact that he violated an injunction a month afterwards to such a high level and serious nature by cutting the victim, breaking into her house. So He does have a criminal history. He's actually, I'm waiting on the conviction confirmation with the actual fingerprints, but I have information that he was federally indicted just as recently as 2021. Indicted in 21 or sentenced in 21. There's also a criminal history that we have that includes multiple misdemeanors, including driving offenses, resisting without violence. He does also have the grand theft charge. The federal indictment is for manufacturing of methamphetamine and amphetamine. So he, depending on that federal indictment, he could be PRR, and because he's facing a PBL, I believe that the serious.
Yeah, I mean, that's significant time. If you are guilty, I don't know, but I'm gonna leave the bond the way it is. All right,
Yes,
thank you.
All right, so
Livingston.
We have Derek Lewis.
That was Mr. Lewis.
Oh, I'm sorry.
Yes.
This is Mr. Livingston. Miss Lige is in another.
Right, right.
Okay, so this
Judge,
is.
you want
this
to
is
pass her
Livingston.
until last? We've got two of those.
This is Livingston?
This is Mr. Livingston.
Okay,
Judge.
all right, that's what, yeah, okay. It's Michael Stephen Livingston. Okay.
Judge, this one is going to be a negotiated plea.
Mr. Livingston, would you please raise your right hand and be sworn? You swear the testimony you give for this court's truth, so help you God.
Yes, sir.
Thank you.
Score sheet on it. Michael Livingston. Oh, you know, you're right. It's 2 minutes. We don't need one. Judge, it's a plea to an LIO battery. So we won't need a score sheet. Battery and resisting.
All right, Mr. Livingston, you want to enter a no contest plea to 2 misdemeanors. One is battery, and the other is resisting without violence, correct?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Where the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
Absolutely not.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
You happy with the work Mr. Williams has done for you on your case?
Yes, sir, Your Honor. He done a fantastic job.
It looks like it, down from what, a life possible sentence down to a misdemeanor?
Yes,
Yes, sir.
Pretty good.
Yes, sir.
All right, court finds the plea is freely and voluntarily entered. Court accepts it. On count 1, the battery, a judge guilty, 12 months supervised probation, have a drug evaluation treatment, random UA, no contact, no violent contact with Rhonda Adams. She agreeable to that, Miss Leon?
It's mine, Your Honor.
Miss Glisson, she's agreeable? Okay, no violent contact with Rhonda Adams,
Yes, sir.
okay? Who is that?
My Aunt Renee.
Aunt?
Yes, sir.
Okay. All right, $50 cost to prosecution, misdemeanor court costs, and in count 2, that's the resisting without violence. Judge guilty, 12 months supervised probation concurrent with count 1. And court orders you not to break the law in the future.
Yes, sir.
Okay, thank you.
Judge. All right, thank you, Your Honor.
Good luck to you.
Thank you, Ms. Gleason.
Whoever requests the supervision fees be waived, Your Honor.
Yes, I'll waive the supervision fees.
Thank you.
All right.
You guys have a good day. Thank you.
Long, Shane Darrell Long.
Yes, sir.
Do we have Destiny Lige, too? Shane Long?
Yes, sir.
Is this a plea?
It's a bond hearing, Judge.
Oh, okay.
Judge, he's been incarcerated since December 19th. His current bond is $3,000 cash or professional. He advises he can't make that. He's asking the court to consider a signature bond. He's employed with J&J Welding in Milton, has been for the last 1.5 years, resides here locally. His address is in the motion, and has lived in this area for 38 years. The underlying offense is possession of a firearm ammunition or electric weapon by a convicted felon, and then a third offense, DWLS, and a second offense outside of 5 years, DUI, do ball. In terms of dealing with any substance abuse or alcohol issues, a monitor could be utilized to deal with that.
Well, what does the state say?
He does have a failure to appear. I'm looking at the first appearance paperwork. He does have a prior failure to appear conviction. He also has got prior DUI. So originally at first appearance, it was just listed as his first, but it's actually his second. So it's charged as his second DUI now. He also has several misdemeanors, false information, law enforcement officer. He has several felonies dealing in stolen property, grand theft. He does have a battery, criminal mischief, and possession of controlled substance, 2 counts of burglary of a structure, grand theft of a firearm. He did have he has an ROR on the DUI, which was brought in as the first offense, but he has the $3,000 cash professional as to the weapons offense, and he also has an ROR on the driving while license suspended felony. So $3,000 is connected to possession of a weapon. He does score 15.5 months DOC.
So the first appearance judge gave him 2 RORs and a 3,000 cash of professional?
Yes, sir.
That's reasonable with all that, so I'm going to stick with that.
Yes, sir.
Mr. Moore is next on the list, but he's been, from what I can, no longer in the county jail.
Well, Mr. Moore is here on a review, Judge.
For what?
Dwayne Moore was here on a competency review.
Oh, okay. Didn't we have him last time, Mr. Moore?
We may have, Judge. I've got a letter from January 4th recommending that he remain on conditional release in the residential program. I can, it's the monthly progress report.
I think I remember seeing that. Yeah.
Okay.
So.
Saying the same thing on the 31st of January?
Yes, Your Honor. January 31st, 2024, we have a letter from his forensic case manager saying currently we are requesting the court that he remain on conditional release in our treatment.
Yeah, that's what I thought I remember seeing. So we'll do that.
All right, Judge. That's what I think
Send me
we've
an
been
order on
doing.
that.
I think I'm looking at the eval from the 4th. You're getting the letter later on, but it's dealing with the same thing. So what we've been doing is setting these out about every 6 months just to keep tabs on.
Send me an order on that. So what else? We have anyone else this morning? Who are these ladies here waiting on?
You're down here for Mr. Benar. And then this lady is here for...
Benar. Which case is that?
That would be Richard Benar.
Where's he on the docket?
Let's see. No, I think it's was it number 19? Let me see. It starts with an A, but it's pronounced Benar. Number 20. Number 20 on the revised
Okay,
docket.
Richard Xavier Benar.
Yes, Your Honor.
They're here for him?
Yes, Your Honor.
Where's he at?
In jail, Your Honor.
Is he here this morning?
He's in jail. Yes, Your Honor. He is.
Okay. Is this a VOP evidentiary or a plea or what?
Yes, Your Honor. It's just going to be set for an evidentiary hearing for 229.
Okay.
Judge, we have one more competency review, and that's on this line.
What about Mr. Gibbs's clients? Oh, this is Richard Xavier Benajar?
That's correct, Your Honor. This is Mr. Benar. He's before the court on 24 CF 116 and 22 CF 2903, 23 CF 146, 23 CF 1544. I'm standing.
Your Honor, Mr. Gibbs, I had asked him I wanted to handle my charges before I handle my VOP, and he essentially told me that I couldn't take my felony charge that brought me into custody to trial. I don't want a VOP trial, or I don't want to accept what the state is offering me, which is what I score out to minus my new charges. So what I scored out to was 29 months, and I want to ask for a continuance or for another resolution, because I know if I take my charge to trial, I will beat it. I'm not trying to be rude, I'm not accepting anything that the state is offering. I want to demand for a speedy trial on my felony charge that I'm in here, that I'm in here on violation for.
Well, has he been arraigned on some new charges yet, or?
Not that I know of, Your Honor.
Did you get arrested on some new charges?
Yes, sir. I got arrested on battery second or subsequent. I want to take that charge to trial. I don't want to have a VOP
misdemeanor?
trial.
It is misdemeanor, and we're gonna try the VOP first. So I'm fine to set it for an evidentiary with subpoenas at 2 p.m. on the 29th, I believe, Mr. Gibbs.
Yeah, I think your misdemeanors, are they in my court or Judge Ward's court?
The misdemeanor will be, he has two new cases. One is a felony, and it's in our court, is the felony battery. And then he has a resisting without violence in the misdemeanor in front of Judge Ward.
But, Your Honor, I don't want to go to an evidentiary hearing. I don't want to do that. I'm not trying to be rude, point blank, period. I don't want to go to an evidentiary hearing at all. So
Your Honor, it's up to the state to decide that.
So you're forcing me to go to an evidentiary hearing at all? That's not what I want to do. I know what y'all trying to do. Y'all are trying to violate me on my probation charges before I can handle my felony charge. That's not what I do. I know what y'all are trying to do. Y'all are trying to get me, and I'm not going for it. I'm not trying to be rude to you, ma'am. I'm not going for it.
Well,
I want to handle my felony charges first.
We can try the VOP at the same time as the new charge, couldn't we?
Yes, Your Honor.
No, Your Honor. No, Your Honor. I would like to try the VOP first on the 29th.
That's not. I'm not going. And then if that's the case, I'd like to ask for another continuance.
Well, what we'll do is you need to have Mr. Gibbs talk to you about it, because he's not here today. I guess he's sick or something. So we'll set it for the 29th, and then if you need a continuance or you want to have Mr. Gibbs talk to him.
So you're telling me that I have to go to it's either go to an evidentiary hearing or accept what the state is offering?
I'm saying we'll set it for the 29th, and then you can talk to Mr. Gibbs and continue it. We'll continue it to some future date for an evidentiary.
Set what to the 29th, Your Honor?
A status.
A status.
So it wouldn't be no VOP trial or evidentiary hearing?
Not on the 29th.
Not on 29th, but I'm not going to say you won't eventually have one. I mean, what I'm saying is I'm concerned that Mr. Gibbs is not here.
Because he essentially lied to me. He told me I couldn't take my charges to trial. I know I have the right to take my charge to trial. That is my 6th Amendment in the Bill of Rights. I could take my charge to trial. And y'all aren't letting me go to trial.
Well, he can. You're good to go to trial, but what I'm doing is I want you to talk to Mr. Gibbs because he's not here.
Yes, sir. And to be honest, I don't even want Mr. Gibbs on my case. I don't want. I would like for him to withdraw from my case. Because to be honest, if this is what it's going to be, I'm putting in a Nelson hearing on it. I'm stating that for the court record. I'm not trying to be rude. I'm not trying to come at nobody crazy. But I'm not. This is my life, bro. Y'all not finna play with my life at all, bro. I know the little game that y'all playing, bro. Y'all not finna do me like this.
All right. Well,
we're gonna. I know I'm innocent on my charge.
Mr. Benar, we're going to continue it to February 29th, so you get a chance to talk to Mr. Gibbs. Thank you.
Love y'all. Be safe, man. Watch out for that door.
All right, so have Mr. Gibbs talk to him about whatever, and y'all see if you can
Yes, Your Honor.
come to some resolution or something.
Yes, Your Honor. Your Honor, this is Nicholas Atkins.
Yes, ma'am.
All right.
Nicholas Robert Atkins, yes, ma'am.
And he's before the court on 23 CF 373, 23 CF 531. Your Honor, there's a... Your Honor, it appears that competency evaluations have been done, indicating that he was not competent and that Mr. Barnes is working on a conditional release plan for the court to accept, but,
I'll bring you back to 29th.
yes, Your Honor.
That's fine, Your Honor.
Okay, thank you, sir. Bring you back to 29th, see about conditional release plan, okay?
Sorry, Judge, gone a tech. What does that mean, yes, sir, gone a tech? I can maybe come home, I can maybe get out of jail because February 29th, yes, sir?
Well, your attorney's going to talk to the state about some type of conditional release program.
Sorry, Mr. Gontek, what does that mean? Can you please tell me?
You may be released on certain terms and conditions, okay?
Yes, sir, that's what Timothy Gibbs was saying. I
But
should get out.
your attorney's not here right now? He's sick or something?
Sick. Yes, ma'am.
So he may be able to work out something with the state for a conditional, isn't that right, Ms. Leon? So a conditional release?
Yes, Your Honor.
So we'll see, okay? You may get out.
I'm sorry, I may get out today, you're saying, Your Honor?
No, the 29th.
29th.
Perhaps, okay?
29th February, yes, sir, Your Honor?
Yeah, maybe.
Yes, Your Honor, I'm trying to go home to my mother. She lives with me called, I just want to simply say 341 West First Avenue, yes, sir, she told me last night. And when I get out, I've been in jail since because Sunday, December 3rd, and I understand that, that's no problem with me. I was going to say, I'm going to work for, it's called the Crestview Walmart Supercenter, yes, sir, in Crestview. I'm trying to get Judge Contact.
All right, well, we'll see. February 29th, maybe we can work it out.
February the 29th, yes, sir?
Maybe you'll get out, maybe. Maybe. M-A-Y-B-E. Or M-A-Y big B. Okay, we got,
Your Honor, this is Stephen Cree. He's before the court on 21 CF 2333 and 23 CF 87.
yeah.
So, Your Honor, my understanding is that Mr. Creech wanted to plea up on one of his cases today, but we would ask to continue it for any, sentencing arguments and recommendations until Mr. Gibbs is back, because I don't know anything about your case, and I don't want to do you a disservice in that respect, okay?
It's fine to continue, Your Honor.
I just continue it to the February 29th,
Or it says February 26th, whichever, Your
It's
Honor.
set for pretrial on,
26th.
Yes,
We'll take a
yes.
plea if that's what he wants to do on that day, and then Mr. Gibbs will be able to argue some mitigation for you. Okay?
Yes, sir.
Okay, thank
Sir, Your
you.
Honor. Thank you.
All right.
Thank you.
Mr. Brown.
Your Honor, this is Chad Brown. He's before the court on 23 CF 2214. Mr. Gibbs had indicated that he was going to have a bond hearing for him, but has asked to continue it to 227 for a bond hearing.
All right. Your attorney's sick today, so we need to have him here to tell me your reasons and all.
That's fine, Judge.
Okay, thank you, sir.
Mr. Crocker. Come on out, please,
Your Honor, likewise for Mr. Crocker, we're going to request a continuance to 227.
No objection.
Okay, see if y'all can get it worked out. Maybe get your case worked out on the 27th.
He doesn't have an acceptance yet from
Oh,
Keaton.
okay.
So, yeah, so we're just,
Yeah, no, that's fine.
once Keaton says yes, then we'll set you
Yep.
for the plea.
Excellent. Thank you so much.
Mm-hmm.
Thank you.
All right, thank you.
Mr. Dale. Stall down.
And your sister-in-law? Sister, okay.
Mr. Dale's sister? Okay.
Your Honor, this is Earl Dale before the court on 23 CF 1454. I'm standing in for Mr. Gibbs today because he's sick. Okay. Your Honor, and Mr. Dale's sister is present. Your Honor, at this point, I believe he's been declared not competent. Conditional release is the plan. But Mr. Barnes has to set up the paperwork for the conditional release. He has not done so. He was in court earlier this morning and said he needs some more time. Sister is present. She is concerned. She says that it's been continued since November for the conditional paperwork. And she said that he's going to lose his place to live. And so she did want to.
What's the problem? What's with Mr. Barnes?
I am not sure, Your Honor. I know that he was supposed to provide this plan, but the problem is that when he was trying to provide the plan, he committed another crime while he was out. So my concern is that if he's just released like that and he's not taking his medication, he's going to incur other charges. So I would rather have Mr. Barnes put together the plan.
Mr. Barnes came to see me at jail. He had it together. Last Thursday when I got out of court, he came and he had it together. He said he had it together and he went over with me at the jail. He came to see me and he said that he would have it ready by the 8th. He came to see me on the 25th when I was in here last time. He came in the afternoon, he had it ready. I looked at it, he went over with me and said he was going to submit it to over the weekend and submit it to the state and public defenders and you. And Mr. Gibbs came to see me and said that he hadn't got it yet. But Mr. Barnes came out to see me and he said he had it ready and he was going to submit it. But he hasn't submitted. I guess I'm thinking somebody intercepted his work. I don't know for sure. But he had it ready.
He was in court this morning, Your Honor, and said that he didn't have it ready and that he could maybe have it ready in another day or two.
Day or two?
Yes, Your Honor.
Well, if he submits it, can y'all submit me some type of stipulated order?
Yeah, if we receive it.
What I'm going to do is have Mr. Barnes, they said, why don't you contact Mr. Barnes and have him submit it, the
Release plan, the pretrial
release plan, and have the state review it, and y'all submit me a stipulated order, and then he won't have to wait till the 27th if that's what the plan says. Okay, so what I'm going to do is I'm ordering Mr. Gibbs or Miss Rivers. He'll contact Mr. Barnes. If he's going to have it in a day or two, put in that order that he's to have it with no later than say that, what's today, the 8th? Yes. Well, no later than 14th. And then get it done, that should be next
Wednesday.
And then y'all review it and then send me a stipulated order. How about that? Okay? All right, thank you. Make sure you put stipulated in there by, y'all stipulate. Don't just send me an order, and it's not stipulated to.
Yes.
And this is Gregory?
Yes, Your Honor, Gregory Geiger, 22 CF 2274, 22 CF 2713. These are violations of probation. Mr. Gibbs is requesting a continuance to 2/27.
No objection.
Okay, February 27th. Thank you, sir.
still have to address the status call on Destiny Lige. That won't take but a minute, though. It's similar to,
All right. You want it, who's doing the detention hearings?
I am, Your Honor, they're my cases.
You and.
I'll do them for the defense judge,
You
since
wanna do
Mr.
'em?
Gibbs isn't here.
Pardon?
I'll do them for the defense judge, since Mr. Gibbs is not here. It was his.
All right, well, I don't have my, I have to take them.
You know, I'm sorry, Judge. One of the defendants is represented by Mike Gilbert, so he doesn't have notice to be here at this time.
Yeah, we'll have to wait till
I just
12:30.
thought it- yeah.
Okay.
Matter to address once you address yours.
All right, now what's your case?
Judge, I have Destiny Lige, 2 cases, 23 CF 1780 and 1530. She was found incompetent to proceed, Judge, and was ordered involuntarily committed. We have a letter dated February 1st of 2024 addressed to Your Honor, indicating that she continues to be incompetent to proceed and continues to meet criteria for involuntary hospitalization. And they recommended she remain at Florida State Hospital, felt like she could obtain competency within 6 months to 1 year. So I'm going to ask that it be set for another review in 6 months. I believe the date that the clerk and I came up with for the other individual was July 30th. And we can get you an order on that.
All right, that's what, I believe she is at Chattahoochee, if I recall, that.
She is,
letter
Judge.
or something, yeah. Okay, send me an order.
Thank you, Judge.
I'd like to address would be, should be towards the end of your docket, Richard Whitfield Sr.
Richard Senior, Richard Whitfield Senior,
Yes, sir.
okay.
And it's 20 CF 2835, 20 CF 2859, 20 CF 2887, 21 CF 443, 21 CF 446. Your Honor, I filed a motion to modify and/or correct his sentences. For today, I just wanted to be able for the court to decide whether to bring him over for the hearing or whether to do it by phone. I need an order to, basically, I'm going to need an order to have him transported here. And the gist of my motion is, he previously signed a plea agreement of April of last year. It said he was to be given credit for prison and county jail time that he had done previously. While in prison, the prison is not giving him all that credit. They have his out date for December of 2025. The state is in agreement that, I can say, the state's in agreement that that does not appear to be the appropriate time for his release date. I have in my motion cited the DOC website for the times he's done in prison, the county jail site for the times he's done in jail, and we're going to have him brought back to have it to where it indicates the number of days he's actually served on each case, so he is properly awarded credit.
You agree, you agree that they've not awarding him the right amount?
Well, Your Honor, the jail and the prisons, they have their own way of determining credit that they award. That's why I don't like promising what credit they're going to get, because if they misbehave in jail or prison, they're going to take that credit away. It's my understanding from the research that I've done, the reason he wasn't awarded the credit was because he had already been sent to prison and put on probation. And when he violated probation, according to the jail, he doesn't automatically get the time that he did in prison. However, because it was my intent, it was the state's intent, and that was the agreement that I was going to agree that he gets that credit. I do think that we are in agreement, even though I think the timeliness of this motion is a little late. But that was the state's intent, so I do intend to honor that. And I'm not sure if that could be done by just court order. It's simply correcting, it's modification really of the sentence, because what we would be doing is adding in the exact number of credit that the state is stipulating the defendant is entitled to. And it's my understanding that the jail will suffice.
So according to the sentencing specialist that I spoke with at Blackwater Correctional, a simple order modification would not suffice. It actually has to be an amended judgment and sentence. He would have to either, she said he'd have to either appear by phone or in person, and we would have to outline the number of days that he was to be given credit for days he actually served. He's not asking for good time credit, he's just asking for days he's actually served.
Send me an order to transport him, we'll bring him in
And Your Honor, if we could set it for the 27th?
Yeah.
And that's all I was seeking today, was to get him set.
Yeah, and have the, if he's entitled to it, he should get it, you know, and then they probably have to have some, okay, I got you. An official amended judgment sentence.
Yes, Your Honor.
Instead of just an order.
Yes, Your Honor.
What else we got?
I don't have any other case.
We having hearings this afternoon?
Not every day.
Your Honor, there is one listed with, for Mr. Gibbs, and it's a sentencing, and since I don't have any information for that and haven't met with that person, we're gonna request that that be reset.
So we don't have actual hearings this afternoon?
I believe that Ms. Bosso has a contested 3850 hearing with Mr. Cobb.
The defendant's name is Menz, I believe, Judge.
Is it right? Yeah.
Carl Menz.
Okay.
But my evidentiary with Mr. Gibbs is gonna be continued because of his illness, so I'm not gonna have any.
That was with who?
With Mr. Gibbs, Bulla Boy, the Bulla Boy,
Oh, okay.
defendant's name.
Are we going, yeah.
Yeah,
We gonna have,
let him know.
we gonna have witnesses for this, this pre-trial detention?
I don't believe so, Your
Okay.
Honor.
I just wanted to know if I had to eat my sandwich fast or not fast, so. Okay, well, we have it 1:30 except for the pre-trial detention at 12:30.
12:30, yes.
How many, do we just have one with private counsel, or is there
Just one with private counsel.
Okay.
Yeah.
Are there any others? What I'm getting at
One
is.
for us and one for them.
One for us and one for them.
Right, right.
All right,
See you later, Your Honor.
thank you. 12:30.
Oh, Ronnie, come back.